Good morning, everyone. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels. A few things before we get started. First of all, of course, for the excerpt we are about to read for the next few days here, you are going to see a link of it right there in the description box. Also included is the link to the first vid that I started with the JRC and why we are going after them again. Also included is the link to the change.org petition to shut down the Judge Rotenberg Center. If you haven't already signed it, please do and share on all your social media platforms. Also, folks, when we are talking about the JRC, there are very detailed descriptions and sometimes depictions of people with disabilities that being tortured. So if you have young ones in the room when you watch these videos, please wear your headphones. Now, what we got today and what we're going to be going over for the next few days is the documents in regards to the counter lawsuit. Basically, the appeal to the ban on the GED 3A and the GED 4 by the FDA. So, this is going to be the JRC's legal document. I'm going to try really not to rant. I don't want to make these videos as long as the others, but there are no guarantees when it comes with these folks. So, we are going to be reading the Judge Rotenberg Education Center Inc. versus U.S. Food and Drug Administration. The fact that they had the balls to countersue the FDA is just mind-boggling. Their ego knows no bounds, folks. So, civil action number 172092. And this was started back after the ban was declared, but before they started making the necessary steps to go ahead and actually enforce the ban. The Judge Rotenberg Educational Center Incorporated, et al. Plaintiff versus the U.S. Food and Drug Administration and U.S. Department of Health and Human Services defendants. God, the balls on these people. Max D. Stern, I can't talk in the mornings. Max D. Stern, Prohack VK, Todd and Welp LLP, Michael P. Flamina, Prohack VK, Eckert Siemens, Sharon and Mellett LLC, Boston, Massachusetts, Edward J. Longus II, Eckert Siemens, Sharon and Mellett LLC, Washington, C.C. for the plaintiffs. William Mark Neckber, U.S. Attorney's Office for the District of Columbia, Washington, D.C. for defendants. Beryl A. Howe, Chief Judge. Okay, moving on. Memorandum Opinion. Beryl A. Howe, Chief Judge, Judge Rotenberg Educational Center, Inc., is described as a nonprofit treatment center for patients who engage in self-interest and aggressive behaviors. For some patients, JRC's treatment regimen includes use of a graduated electronic defibrillator, which is an electrical stimulation device. Stimulation my ass. In 2016, the Food and Drug Administration, a division of Department of Health and Human Services, published a proposed rule that would ban use of the GED. See proposal to ban electrical stimulation devices used to treat self-injurious or aggressive behavior. Proposed ban 81 Fed Reg 24,386, April the 25th, 2016. Following publication of the proposed ban, JRC, as well as the JRC Parents and Friends Association, Inc., Parents Association, oh my God, and Paul E. Peterson, who is the father of an adult patient at JRC and himself a member of the Parents Association. Collectively, the plaintiffs submitted requests under the Freedom of Information Act, FOIA. Oh my God, seriously. 5 USC 552 to the FDA for records related to, among other things, the proposed ban. Now, the defendants, the FDA and the HHS, claim to have partially completed their response to the plaintiff's FOIA requests by producing, with appropriate withholdings, all responsive records. The plaintiffs, however, argue that the defendants have failed to justify or misapplied FOIA's production exemptions in withholding certain responsive records and have otherwise withheld documents without any statutory authority. Really, the FDA has no authority. Wow. God. According to the parties have cross-moved for partial summary judgment. Defendants Mott partial sum, please cross Mott partial sum J for the reasons set forth below. Both the defendant's motion and the plaintiff's cross motion are granted in part and denied in part. On February the 2nd, 2018, the case was bifurcated. The FDA component after the Center for Devices and Radiological Health was put on one production and briefing schedule. CDRH was put on another. The pending motions relate only to the records released by the components in the first group. Background. This section summarizes the regulatory history of the JRC's GED, the plaintiff's FOIA requests, the defendant's response to those requests, and the current litigation posture in this case. We're going to cover a lot to say on this one. God, these people. The FDA's rulemaking for electrical stimulation devices. JRC is a residential program that treats patients who engage in self-injurious problem behaviors, including self-injurious behavior and aggressive behavior. Yeah, they've defined aggressive behavior by literally people who have involuntary muscle tensions due to being electrocuted. Statement of material facts as to which there is no genuine dispute. No genuine dispute? Human rights is not a genuine dispute, folks. Whatever you say, Dr. Mingala. 48 of JRC's patients, all whom engage in life-threatening and treatment-resistant self-injurious behavior. All. Did you hear that? All. That's interesting. They've never claimed that before. Now, all of a sudden, every student there is self-harming? Really? Really? Are treated with the GED, which is an electrical stimulation device. Remember how they used to say that just some students were being treated with the device? Look at that. All of them. Isn't that interesting? Why suddenly change your statement after all these years, JRC? For each patient, a probate judge has determined that electrical stimulation is the most effective, least restrictive treatment for severe behaviors. That's because that court has no good given idea what actually goes on in that center, nor have they ever been strapped to a board and shocked over 31 times. I'm sure if they had experienced it for themselves, they would probably be singing an entirely different tune. Moving on. The JRC treatment methods have been on the FDA's radar for nearly 3 decades, as it should be. In 1991, JRC applied to the FDA for pre-market clearance, also known as 510K clearance, for the first version of the GED, citing Food and Drug Administration, Pre-Market Notification 510K. A 501K is a pre-market submission made to the FDA to demonstrate that the device to be marketed is at least safe and effective, that is, substantially equivalent to a legally marketed device, and is required when a manufacturer intends to introduce a medical device into distribution for the first time or introduce a device that has undergone changes since the previous clearance that might affect the device's safety or effectiveness. Food and Drug Administration, pre-market notifications. The JRC received that clearance in 1994. Blah, 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 blah. In 2000, after the JRC had substantially modified the GED, the FDA, following an inspection of the JRC's premises, advised the JRC not to obtain a new 5010 clearance. Oh, you're going to blame the FDA now. You're going to say that the FDA advised you to not move forward with getting approval on the modified GED devices. Really? Really? Wow. I mean, they cite counsel on that. Wow. A decade later, the FDA notified the JRC that although the FDA told JRC in 2000 that GED devices were exempt from requirement, you got evidence of that? Do you have evidence saying that they were exempt that comes from the FDA? I want to see the documents. The FDA explained that the GEDs are devices under the Food and Drug and Cosmetic Act and must receive 510 clearance before marketing. Thus, the JRC was told to submit new 510K paperwork for the GED because of modifications made since 1994. Thank you. First of all, that's confusing. First part of the paragraph said they were told they didn't need clearance. Second part of the paragraph says they were then told that they did. Which one is it? Oh my God. I thought AH's lawyers were bad. At the FDA's request, the JRC provided pre-submission in February 2013 in anticipation of the JRC's eventual 510K application. The parties set a meeting for March 25, 2013 to discuss the pre-submission, but the FDA canceled the meeting shortly before the scheduled date. Oh, we're gonna blame the FDA again. It's all their fault, folks. Jesus Christ. Around the same time, the FDA met with anti-aversive advocacy groups and several former JRC patients. Oh, and it's our fault too because we are against, people being like freaking electroshocked within an inch of their lives for, daring not to take off their coats or, standing up in class. How awful of us. For the year between March 2013 and April 2014, the FDA and the JRC representatives did not communicate. Again, blaming the FDA. These people got balls, I'll give them that. JRC received notice that a committee of the FDA's Center for Devices and Radiological Health had organized a panel on neurological devices, which panel convened on April 24, 2014. And heard testimony, inter alia, from 2 former JRC patients and 1 former JRC employee. The panel was divided on the health benefits of the GED. 2 years after the panel convened, the FDA on April 25, 2016, published a proposed ban, which, if finalized, would prohibit JRC's use of the GED, as they should. The FDA has not published a final rule. Well, they have at this point, thank God. So, basically here, what they are trying to do is they're trying to shove blame off onto the FDA. Can you believe that? They are trying to say that first the FDA said we were exempt, then they told us we needed to do it, but they kept postponing the meetings. They're passing the buck. Here's the fact of the matter, JRC. Whether or not you were told these things, it's only common human freaking decency, or even if you don't have that, just a sense of self preservation, that you use that which is already approved and wait until you can get a hold of a person before you go and use the modified devices. It's called being smart. Now, none of these devices are actually humane, mind you. It's just the fact that even without approval, they went ahead and used the modified devices anyways and didn't expect any repercussions is completely insane. Throwing but nothing. You had zero approval to use the modified devices at all, point blank, period. Whether or not they kept putting off meetings, that's neither here nor there. You still went forward with no approval and used those devices on vulnerable kids with nowhere else to go. Okay? You did that. The FDA did not do that. You did. Okay? You did not get approval for those devices. So the fact of the matter is, how can you still not only just defend their use, but have the balls to sue the FDA over your own negligence, under your own inhumane treatment of vulnerable people? I don't get it. I really don't get it. So, this is probably going to be an eye-opener as we kind of go through each of these sections. It's not nearly as long as the last document that we went through, folks. We'll probably cover it here in about 2 or 3 days. But I wanted to go ahead and close it out with that. Now, before we head out, folks, as always, we don't get many views on this channel. And the few that we do get do tend to get removed from time to time. So please don't forget to hit that like button, hit subscribe. And as always, folks, please don't forget to hit the comments. I do appreciate your time this morning. And as always, folks, we here at Spilling Tea hope you have a good one. Bye-bye.